Well, good evening, everyone, and welcome to the Ross Parsons Centre Law and Business webinar for this evening. Tonight's topic is Law Reform and the PPSA, why we should delete Section 267 and the Corporations Act Section 588 FL. For many of you on the line, you'll be aware that the PPSA had a review several years ago now, and by Bruce Whitaker from Ashurst. And the government has thankfully, after several years, responded to that comprehensive report that Mr. Whitaker did and provided its response last week, which touches on the topic that we're going to be discussing tonight, which concerns the vesting rules in the PPSA, Personal Property Securities Act, and the relevant vesting rule for PPSA, unperfected security interests in the Corporations Act, Section 588 FL. The purpose of these Downtown Law and Business webinars, which were started many years ago by my predecessor, Professor Hill, which was a seminar series at that stage, is really to try and highlight some of the fantastic research that we're doing here at Sydney Law School. And from time to time, we also have external academics present on their research. So really, we're trying to showcase some of the excellent research that we do largely for a practitioner and business audience. And tonight, I'm delighted to introduce our presenter, who is my colleague, Adam Waldman. Adam is the Colin Fegan Associate Lecturer here at Sydney Law School, and he's also undertaking his PhD looking at different aspects of the PPSA, including tonight's topic. Adam teaches equity and introduction to property and commercial law, torts and contracts too, and legal reasoning here at the law school. Adam is also a lecturer for the Legal Profession Admission Board's Diploma in Law, where he lectures on personal property in commercial transactions. So the topic for tonight's discussion. Our commentator for this evening is Tony Ryan, who is a consultant at Ashurst. He's a former partner of Ashurst for many, many years, here in the Sydney office in the restructuring, insolvency and special situations practice. Tony's worked on some of Australia's largest and most complicated insolvency and restructuring matters, including HIH and MF Global. Tony is the New South Wales co-chair of the Insolvency and Restructuring Committee of the Business Law section of the Law Council of Australia. And Tony is also a colleague here at the law school, where he teaches in insolvency and corporate finance law in both undergraduate and postgraduate. So gentlemen, thanks so much for giving up your time. Just in terms of housekeeping, so there will be some time set aside for questions from those who are attending the webinar tonight. If you could use the Q&A button on your Zoom toolbar, and then we'll get to the questions at the end of the presentation. So probably the last 15 minutes or so, we'll have some time for questions. This session is being recorded, and a link to the recording will be emailed out to all of the attendees. And Adam has kindly offered to release his draft paper on this particular topic, which we will also send out to everyone who's registered for the session tonight. So without further ado, I'll hand it over to you, Adam.
Great. Thank you very much, Jason. I will just share my slides and just bear with me for a moment. Okay, so tonight's paper is entitled Law Reform and the PPSA, and I'm, like Jason just alluded to, presenting a version of a full paper which will be made available to you later with a slightly more unwieldy name, which is Unperfected PPSA Security Interests in Insolvency, Why We Should Delete Section 267 and Corporations Act 588 FL. And the couple of things I just want to flag before I jump into the substance of the paper. The first thing is just to emphasize that really what I want to do tonight is talk through some of the key points. I won't have time to talk through everything. The paper itself is quite long because I've tried to address all of the possible rationales underlying these provisions. So my goal in the 35 or so minutes in which I'll talk is really just to focus on the ones which I think are the most significant. I also thought I'd just briefly flag how this paper came about. Like Jason said, I'm doing my PhD. It looks at the relationship between equity and the Personal Property Securities Act, and Jason is in fact my lead supervisor. And one of the things I was doing in the course of the current PhD chapter, which I'm looking at, was looking at this broader question of, well, does the PPSA aim to protect unsecured creditors? And that then started to lead me down a couple of different rabbit holes, one of which was, well, maybe that's something 267 and 588 FL are trying to do. And that then in turn led me to go, well, what is the actual goal of these provisions? If they're not doing that, as I'll talk about later, what is it that they're actually trying to achieve? And that's what led me to writing this paper, in which I adopt a conclusion which I really didn't intend to when I started setting out to look at these provisions, which is that I don't think these provisions are actually necessary for the operation of the PPSA. And thus I argue we should delete them. And the other impetus I should flag in the course of that is, just for those who aren't aware, the Personal Property Securities Act in New Zealand, which is one of the statutes on which the Australian PPSA was modelled, in addition to the various provincial Canadian statutes. In New Zealand, the statutory drafters made a policy decision to not include a counterpart to either of these vesting provisions. And so that was also part of the impetus that got me thinking, well, maybe it actually is conceivable that this provision, which I spent quite a lot of time teaching in the various courses where I teach PPSA, maybe it's not actually necessary. So that takes me to the first part of my paper, which looks at the operation and the commercial significance of these two provisions, PPSA Section 267, Corporations Act Section 588 FL, which I will collectively refer to as the vesting provisions. And the first thing that I do is just talk through how these provisions actually work. Now, I'm sure lots of you in the audience will be very familiar with this, but I will just take a step back and do a little kind of brief overview. So starting with Section 267 of the PPSA, what this says is, if you have an unperfected security interest, and the security interest remains unperfected at the time that the grantor enters into an event of insolvency, and those events are specified in the Act. They include the appointment of liquidators, of a voluntary administrator, entering into a restructuring plan, and also events such as a sequestration order or becoming bankrupt where the grantor is an individual. They say if those two requirements are satisfied, the security interest vests in the grantor. And the effect of that is that you, as the secured party, lose your security interest. That security interest becomes part of the grantor's estate, and consequently you, as the secured party, now become an unsecured creditor. So that's 267, where you as a secured party have a security interest, you don't perfect it, and then one of these events of insolvency happens. That is then complemented by Section 588 FL of the Corporations Act. 588 FL of the Corporations Act kind of builds upon the first one, 267. What 588 FL says is that if the grantor is a company and the security interest is perfected, so it's not caught in 267, but it's not perfected within a sufficient time period in relation to the grantor's event of insolvency, the security interest vests in the company, which is substantively the same thing as it vesting in the grantor, because the company will be the grantor. So the collective effect of these two provisions in most cases is this: to avoid 267, you need to perfect your security interest before the grantor becomes insolvent. And to avoid 588 FL, in most cases, you will either also need to do so within 20 business days of the date of the security agreement, or more than 6 months ahead of the event of insolvency of the corporate grantor. And there are some further exceptions there. We don't need to go into them. One thing we may flag, and I know Tony, I think, is going to speak on this later, there are some orders that you can get to extend time in relation to 588 FL, but the same thing can't be achieved under 267. So that's hopefully the most boring part of this presentation out of the way. There's a brief overview in the abstract of what they do. What I now want to talk about is, well, what is their commercial significance? And I'll start with Section 267 here. And there's really only 2 points that I want to make. The first is that Section 267 is not essential for the priority regime enmeshed within the PPSA to work or to function properly as it's contemplated. And in fact, in most cases, Section 267 won't actually lead to a different priority outcome than would already occur under the priority rules and the taking free rules of the PPSA itself. So, for example, if I'm in a priority competition with Jason, I hold an unperfected security interest and Jason holds a perfected security interest, and the grantor then becomes insolvent. What currently happens is, well, my security interest vests in the grantor, and thus effectively I lose my security interest, Jason wins. On the other hand, though, if we deleted section 267, Jason will still win, because the priority rules say that a perfected security interest, which he has priority over an unperfected security interest. The same thing is true where we have competitions with purchasers. So if instead of holding a security interest, Jason is now a purchaser of the collateral, again, what currently happens, my security interest is unperfected, it vests in the grantor, Jason can thus purchase the collateral, he doesn't have to worry about my security interest, it has formed part of the grantor's estate. But if we deleted section 267, we still get to the same outcome, because Jason will take free of my unperfected security interest under the taking free rule, which is section 43 of the PPSA. So that's point one. In most cases, section 267 doesn't lead to a different priority outcome. That leads me to the next and related point, which is to say, well, where section 267 does lead to an outcome that we wouldn't get to under the current rules of the PPSA anyway, its main effect is to redistribute the value of security interests away from secured parties, which is me in that example, and towards unsecured creditors. So where it will tend to make a difference is where Jason is not in the scenario. You've got your insolvent grantor, it's just me with my unperfected security interest. Because of 267, my security interest vests, thus the value of that security interest is effectively redistributed from me and towards all of the unsecured creditors, of whom I will be one, but possibly one of many. The other case where it may make a difference is where, again, Jason has a security interest that is perfected, but it doesn't exhaust the value of the collateral. And so Jason enforces his security interest, and thus it leaves a shortfall. And once again, the effect of 267 here is that instead of that shortfall going to me with my lower ranking security interest, because of 267, that security interest has vested, thus I am an unsecured creditor, and value is redistributed away to the body of unsecured creditors. Now, before I move on, I should flag, I don't think that's necessarily some kind of terrible thing, right? That we have this provision and it redistributes value away from secured parties who don't perfect their security interests towards unsecured creditors. What I do think, though, is that there should be some convincing or compelling policy reason as to why that is necessary. Now, before I get to that, I should just briefly speak to the commercial significance of section 588 FL, or rather what I'm going to do here is just dodge speaking about the commercial significance of section 588 FL. I go through this in the substantive paper. A copy of that will be distributed. 588 FL is a little bit more complicated because in some cases it does lead to different priority outcomes than we would otherwise have under the PPSA. But in summary, what I argue in the paper is that one, again, it's not necessary for those priority rules. Two, in many cases, its effect is going to be, again, to redistribute value towards unsecured creditors. And thirdly, where 588 FL does lead to a different priority outcome, there's no convincing policy reason as to why that is necessary. So again, it's really just not essential for the priority regime of the Act to work. So that's part one of my paper. My fundamental argument is the main effect of these provisions is to redistribute value to unsecured creditors. And in other cases, there's no convincing reason for why they lead to different priority outcomes. That then brings me to the point that I was touching on just a moment ago, which is to say, well, if we have these provisions and they are redistributing value in the way that I've just described, well, what's their purpose? Why are they doing that? Because if there is some convincing reason for that, then we can probably say, well, okay, that's entirely unobjectionable. But if there isn't, that may suggest that these provisions are detrimental to those secured parties and that there's no reason why we need to cause those secured parties to suffer that detriment. So in the second part of my paper, I then turn to, well, what are the possible policy objectives for the vesting provisions. And in part two, I focus on the main policy objective, which is the continuation of previous statutory provisions. So the idea here is that the main reason we have 267 and 588 FL is to directly continue previous statutory provisions which were repealed when the PPSA was brought into force, which required the registration of certain security interests or documents in respect of those interests. And the most important of those previous statutory provisions were the ones which required the registration of company charges. Those are explicitly referenced in the explanatory memorandum for Section 267, and the continuation of those statutes is even more clearly the purpose of Section 588 FL, because Section 588 FL actually is the direct continuation of the previously repealed Section 266, which combined with Section 267 of the PPSA had a similar effect. The other statutes which these seek to continue, and these are often more raised in the context of Section 267, are the bills of sale statutes. These are probably a little bit less significant in terms of the objective of continuing those previous provisions, and I speak about them in the paper, but I won't seek to address them in any detail today. Now, having said that, what I argue is that a policy objective of continuing a previous statute which has been repealed cannot actually be a good policy objective in and of itself. Rather, it just raises this further question of, well, what did those previous statutes themselves actually seek to achieve? And do the new vesting provisions achieve the objectives of those previous now repealed statutes? And so that's what I look at in part two, focusing mostly on the more significant, the company charges register provisions. The first underlying policy of those previous statutes requiring the registration of company charges was that these statutes were brought in with the objective of protecting unsecured creditors. Let me explain how that works. The idea here is that there was this concern being raised in England around the end of the 20th century that companies were granting floating charges, and those floating charges were covering all of the assets that that company owned. But it was impossible to tell whether or not a company had actually granted a floating charge, or at least to verify whether the company had granted that floating charge. And the concern was that if I'm such a company, I've granted a floating charge over all of my property to Jason, and Tony wants to come along and make a loan to me, it might be difficult for Tony to actually tell whether Jason has some security interest, which is thus going to sweep away all of the value of the loan that Tony may make if I become insolvent. So that's why the company charges register was initially implemented. The idea now is that if Jason wants to enforce his floating charge against me, the company, he needs to make a registration. And that allows an unsecured creditor in the position of Tony to do a search of the company charges register, figure out whether I actually have granted any charges, and thus take that into account in deciding whether or not he's going to make that loan to me. So it doesn't actually protect the unsecured creditor in Tony's position from Jason's security interest, allowing him to come in and sweep away all of the value of my company when I become insolvent. But what it does do is at least help him to make an informed decision. Now, at least in theory, that's how it worked. The argument that I make in the paper, though, is essentially that this objective never really worked in the first place, and thus that it cannot justify the vesting provisions which have replaced that previous register. And the reason why the protection of unsecured creditors was never affected particularly well by the predecessors to the vesting provisions is that even though it allows Tony to come along and make a search before he decides to make a loan to me, there's nothing to stop me the day after Tony makes the loan from going off and encumbering all of my assets, at least within the other protections within insolvency law. And so for that reason, the protection afforded to the unsecured creditor is not a particularly powerful one. I can still later go out and grant a floating charge to Jason, which allows him to sweep away all of that value. So that's my first argument, that The vesting provisions don't protect unsecured creditors because even though they seek to continue that from the previous statutes, the previous statutes never worked especially effectively at doing so in the first place. The second and related point that I make in my paper is that this is even worse now under the PPSA than it would have been under the Company Charges Register. And the reason for that is because the PPSA's register, the PPSR, adopts a notice filing system rather than a document filing system. So under the Company Charges Register, a verified copy of the security agreement actually had to be lodged. And that would mean that an unsecured creditor could come along and inspect that agreement, or at the least, they could obtain a whole bunch of key information with respect to the nature of the charge and the secured obligation that the charge did secure. This is no longer the case under the PPSA because the way that the notice filing system works is that anyone can make a registration of a financing statement. That financing statement can be relatively bare in the amount of detail that it covers. And if you discover a financing statement, it is then incumbent upon the searcher to go and to make further inquiries. So my argument is thus that even if the company charges did protect unsecured creditors, which I argue in accordance with observations of some senior judicial figures in England, that it didn't actually do in the first place, this is even further weakened by the nature of the register under the PPSR, as opposed to the nature of the Company Charges Register. That then brings me to the next, and probably I think the next most important underlying objective of the Company Charges Register. And the argument here is that even if the Company Charges Register did not protect unsecured creditors, what it did do is protect other prospective secured creditors. Again, I might just use an example. So again, we have this problem that I, a company, might have granted a charge to Jason. Tony might be considering taking a second charge from me over the same property, but it may be impossible for Tony to tell whether or not I have granted any other charges. So under the Company Charges Register, by requiring Jason to make a registration, we allow at least say, well, if there's no other registration, I can have confidence that his charge will have priority over any subsequently granted charge. This I accept is quite a compelling reason for a Company Charges Register, and I think it's one of the reasons that continues to justify the existence of such a register under English law today. However, my argument is that it's not necessary under the PPSA, and that's because the priority and taking free rules already sufficiently account for such competitions. Because even if we don't say that an unperfected security interest, and thus one in respect of which there is not a sufficient registration as well as other requirements, even if we don't say that that vests in the grantor when the grantor becomes insolvent, the prospective secured creditor can still rely on their earlier registration to afford them priority over the unperfected security interest. And a similar argument can be made with respect to purchases as well. Now, I should flag one kind of quick point on that before I move on to the next part of my paper, which is to flag under Australian company charges law, but not in England, the law was changed so that there were actually competitions between registered interests which were determined by their time of registration. And so something that you could say to me is, well, Adam, if that already existed, why is that different under the PPSA? And my argument is that even though Australian company charge law from 1982, when they made the amendments onwards, even though it did determine priority between competing registered charges, it did not determine priority between a registered and an unregistered charge, or between a registered charge and a purchaser of the collateral over which the charge is, which the charge covers. So to the extent that the previous registration system did still require rendering unregistered charges void in order to protect other prospective secured creditors and also purchasers, my argument is that, well, we don't actually need this anymore because the PPSA's priority and taking free rules are comprehensive when it comes to such competitions. Now, those are my main points in terms of the main policy objective of the vesting provisions and why I say that continuing previous statutory provisions cannot justify the new vesting provisions. I should flag that I also do address these other 2 points in the substantive paper. I talk about the notion that the company charges register was used to assess the creditworthiness of companies. I also talk about this notion of ostensible ownership, which is wound up in the bills of sale statutes. And the arguments that I make in the substantive paper is that neither of these can justify the vesting provisions either. That then takes me to part 3 of my paper. Having addressed the main policy objective, which the vesting provisions seek to achieve, the next thing that I look at is, well, aside from that, there are several other different possible policy objectives of Section 267 and also for some of them of Section 588 FL. Now, in my substantive paper, I go through 6 of them, being all of them that I have identified, and I address them in depth. Thankfully, I'm not going to take you through all 6 today in the interests of time. What I do want to focus on is just the first of these other possible policy objectives of the vesting provisions, which is that these provisions are said to make it harder to fraudulently assert a security interest in the grantor's insolvency. And I should flag that this other possible policy objective is probably a particularly important one, because in the recent government response to the statutory review of the PPSA, the Whitaker Report as it's commonly called, the government rejected Bruce Whitaker's proposal that we should delete Section 588 FL. And the reason that it gave was that it said Section 588 FL was necessary to prevent fraud. So that's the first thing that I address in these other possible policy objectives. And I argue that the prevention of fraud cannot justify 588 FL, and also, for that matter, that it cannot justify Section 267. So let me start then with how this works. The idea of the vesting provisions as preventing fraud is that if you are trying to fraudulently assert that you hold a security interest in an insolvent grantor's estate, the vesting provisions mean that if you haven't got possession or control of the collateral, you need to make a registration before the event of insolvency, and you need to make that registration within the relevant time periods for Section 588 FL, which in most cases is going to mean within 20 business days of the purported security agreement. I should flag that I do think this is probably the most convincing explanation for Section 267 and 588 FL. I entirely agree that these provisions do add a further layer of protection against fraud. They ensure that if the fraudulent party fails to make a registration prior to that event of insolvency, it is too late for them to subsequently assert a security interest, because any purported security interest that they may hold would have vested in the grantor anyway, and thus would no longer exist. What I do argue in my paper, though, is that I don't think this justifies the vesting provisions, because there are already other provisions which are aimed at protecting fraud, and I think those other provisions do a sufficient job of preventing the assertion of fraudulent security interests without the further need for Section 267 and 588 FL. One of those provisions which is really important in the PPSA itself is Section 20. Section 20 says that if you want to enforce a security interest against a third party, you can only do so if you meet certain requirements, and unless you have taken possession or control of the collateral, those requirements require there to be written evidence of a security agreement. The precise requirements are ever so slightly more technical. We don't need to get into them. Section 20 has been described as a statute of frauds type provision, because what it's trying to do is say, well, if you do want to assert the existence of a security interest to the detriment of third parties, you need to corroborate the existence of that security interest, in most cases by showing that there is writing evidencing the genuineness of a security agreement. And that writing would, of course, actually, sorry, I won't want to make that next statement. So that's the first point. Section 20 already aims at providing protection against the fraudulent assertion of security interests. And the other thing to flag is that because our concern is in the context of insolvency, because that's where 267 and 588 FL apply, there are also a whole bunch of different protections against the fraudulent assertion of security interests under insolvency law. And in particular, what I'm referring to are the various clawback provisions, which historically, many of which have already performed a function of preventing fraudulent security interests from being asserted. And those include, for example, a liquidator being able to challenge a transaction or a security interest as being an uncommercial transaction under the Corporations Act. Also, many of these fraudulently asserted security interests are going to be ones where the person asserting the security interest is related to the corporate grantor, such as a director or a relative of the director. And those are also going to be caught by several existing protections in insolvency law already in relation to director-related transactions and security interests granted to directors and other related parties, which are attempted to be enforced within a certain time period of the company's insolvency. So my ultimate I've missed one further point, which is this. The last point on the protection of fraud is just that there isn't actually any evidence that there are widespread practices of the fraudulent assertions of security interests in the first place. There doesn't seem to be any in Australia. It also doesn't seem to have been an issue, at least that we're aware of, in New Zealand, where they don't have a counterpart to the vesting provisions. And so my ultimate argument is, well, if we can't say, well, this is a substantial issue in practice that we need further protections against, and we can say, well, there are already other provisions which provide protection against fraud, both in the PPSA and in insolvency law, I don't think this further layer of protection provided by 267 and 588 FL is necessary. Now, I quickly added on the slide the other 5 possible policy objectives, which I go through in the substantive paper. I'm very happy to take questions on them if anyone wants to discuss them, but I am just going to fly through them. I'm going to fly past them for the moment to get on to the last point that I want to make before I hand over to Tony. That is the ongoing costs of the vesting provisions. So by way of summary thus far, what I've said is, here's what the vesting provisions do. Most significantly, they redistribute value to unsecured creditors, and they're not necessary for the priority regime. And then I've said, I don't think there's any convincing policy reason as to why we need to make those redistributions. You could still turn to me, I think, at this point in time and say, well, Adam, look, I understand that you say there's no convincing reason which explains why we need these provisions, but they have been a part of English law and thus Australian law for over 100 years. So surely we should only remove them if there is some kind of compelling detriment you can show that they're causing, and thus an actual case for law reform. So that's what I address in the last part of my paper. I identify 3 costs of these vesting provisions, which I suggest would be addressed by deleting them, and thus which show that there is a case and a need for law reform to address these problems. The first of those which I look at is this notion that the vesting provisions further subvert the expectations that are associated with ownership rights. So what I mean by this is, under the PPSA, the security interest is much wider than analogous notions under previous statutes. And in many cases, it can arise from ownership rights that the secured party holds, which would previously have not been caught by statutes which had broadly similar effects to the PPSA under pre-PPSA law. Those ownership rights, which are then characterized as security interests, are treated as such under the PPSA, and the PPSA does not distinguish between security interests based upon the form of the underlying interest. And so consequently, those security interests arising from ownership rights may vest in the grantor or vest in the company, and thus further subvert the expectations that many commercial parties have that are associated with ownership rights. Now, I need to flag what I am absolutely not arguing. I am not saying that we should treat such security interests differently to how we treat all other security interests. It is an inevitable consequence of the design of the PPSA and its substance over form approach that we treat all security interests equivalently regardless of their underlying form at general law, or regardless of the form of the transaction which gave rise to the security interest. So there's nothing we can do, and nor should we necessarily do anything, in my perspective, about the fact that an owner of property whose ownership interest becomes a security interest may lose out to someone under the priority regime of the PPSA. What I do argue, though, is that there's no need to further subvert their expectations by causing them not only to possibly lose out to other parties under the priority regime, but also to lose out to other parties and largely to unsecured creditors because of the effect of Section 267 and 588 FL. Now, there's one other point I make here, which is to say, well, if the problem of the vesting provisions is just associated with these types of security interests, ones which arise from the ownership that the secured party holds, couldn't we just more discreetly address the scope of Section 267 and Section 588 FL? And the argument that I make in the paper is that we can't do that, because if we start distinguishing based upon whether a security interest arises from ownership, well, that's fundamentally contrary to how the Act works. Now, I should briefly flag one other related issue that comes up here, is we could partially address this issue by one of the proposed changes in the statutory review, which has been accepted in the government's recent response, which is to say, what we can do is just carve out certain types of deemed security interests arising from long-term leases from the scope of 267 and 588 FL. And if we do that, that would at least minimize that problem. The problem that this gives rise to, which has been identified in the commentaries and which I draw upon in my paper, is that sort of defeats one of the main purposes of deeming those arrangements to be security interests in the first place. Because now we're going to have disputes about whether a given long-term lease does in fact secure payment or performance of an obligation, because even though it will be a security interest either way under 12.3c or 12.1, it may now make a really big difference because it'll determine whether that security interest is caught by 267 and 588 FL. And that's what leads me to conclude that somewhat counterintuitively, the best way to address this narrow problem is not with a discrete amendment, but actually with a broader amendment that just deletes 267 and 588 FL altogether. There's one other cost I'll speak to, and then I'll hand over to Tony. That is that the PPSA can be especially detrimental to small businesses. And the argument here is that small businesses are likely to have less access to resources, and thus they are more likely to either not know that they have a security interest which they need to take steps to perfect, including making registrations in many cases, or they may know that but not have the knowledge of how to make an effective registration. Now, there are, of course, other solutions which would minimize the detriment which we can and should implement, and many of these were recommended by the Whittaker report, and happily it does look like the vast majority of them has been accepted in the government response. For example, in part, we should be addressing the detriment caused to small businesses by engaging in a new education campaign that was accepted in the index of the government response to the Whittaker report, although we don't have any further details yet. And the other really big thing to do is to make sure that registration is much easier, and there are lots of detailed recommendations which have been accepted with respect to that. What I argue in this paper, though, is that even if all of those are implemented and they are implemented effectively, which I hope they will be, many small businesses are still going to fall through the cracks. And to the extent that those small businesses do still fall through the cracks, they still don't know how to make proper registrations, or they don't know that they need to make a registration or otherwise protect their security interest in the first place. The effect of 267 and 588 FL is to kind of further penalize them for that. It's to say, well, not only are you going to be at risk of losing out to other secured parties, purchasers, lessors, you're also going to be at risk of having your security interest vest in the grantor, and thus of losing out to unsecured creditors. And again, this is a solution that would be resolved by deleting the vesting provisions altogether, which would minimize that further risk, which I argue is unnecessary. And I'll briefly flag, again, you could try and address this through a more discrete amendment. One proposal that was made to the Joint Parliamentary Committee on Corporations and Insolvency was, well, maybe we could just carve small businesses out of the scope of 267 and 588 FL. But my concern with that is, again, it may give rise to the further problem of complexity. And that problem is, well, now an insolvency practitioner needs to start distinguishing between secured parties and saying, are you a small business or not? Are you a small business or not, etc., which may add significant costs to the administration of the insolvent grantor. So again, we have this problem, which is a discrete problem. But if we try and just target it, it can give rise to further problems. And that's why I argue, well, in fact, then the best way to address it is to delete the vesting provisions altogether. Finally, I've got a brief argument that maybe Section 267 and 588 FL can lead to kind of economic inefficiencies, which factor into an increased costs in accessing secured finance. Again, I'll refer you to the substantive paper to that. So in conclusion, in a nutshell, my argument is there's no clear and convincing reason why we need PPSA Section 267 and Corporations Act Section 588 FL, but there are several costs that they give rise to, which we cannot resolve through more discrete amendments to their scope. And that leads me to this conclusion, which may at first seem quite radical and is certainly not something that I thought I would be advocating for when I first started looking into the provisions. But it nonetheless leads me to the conclusion that we should delete Section 267 and delete Section 588 FL altogether. So I'll hand back to Jason, who I think will introduce Tony, or perhaps straight to Tony. And I very much look forward to any questions or comments that you may have.
Thanks, Adam. And I'll now hand over to Tony for his
comment.
All
right, thank you, Adam, very much. At the outset, I'd like to commend Adam's presentation and his paper. I thought it was a meticulous, thorough and thought-provoking work of research. It's certainly the most detailed interrogation of which I'm aware of the policy justifications for the vesting provisions associated with the personal property security regime. It's impossible in the course of a brief commentary, I think, to do justice or cover all or even a substantial part of the territory that Adam has addressed in his paper, but I would like to draw on a few themes for consideration. One interesting comparison is between the Whittaker report process and the New Zealand Law Reform Commission process. I found it intriguing that when the New Zealand Law Reform Commission considered its own proposed PPSA, there was, it seems, considerable focus, indeed described as hot debate by at least one commentator, as to whether or not it should provide for the vesting of unperfected security interests on insolvency. In summary, the Law Reform Commission, its report number 8 on the proposed Personal Property Securities Act for New Zealand, was almost evenly divided on the point, although ultimately, it seems by a bare majority, took the view that vesting was unnecessary as a feature of their legislation. It's worth contrasting the NZ approach to our own Whittaker review. I think importantly noting that there the Law Reform Commission considered the issue at the outset rather than sometime down the track. The New Zealand report considered, interestingly, that in practice only two parties could be misled by the absence of a registration. The first were prospective creditors, and the Law Reform Commission view, as expressed in the report, was that prospective secured creditors who registered on taking security were protected from unperfected security interests, and therefore that was not something they need to be concerned with, and took the view that creditors who supplied goods or funds on an unsecured basis were generally not concerned about the presence of outstanding interests or assumed that such interests existed, which I thought was interesting practical observation. The second category that the report identified was prospective buyers and lessees who were protected by unperfected secured creditors unless they have actual knowledge of the security interests by provisions similar to our take-free rules. And the report there indicated actual knowledge was the test. So it's worth noting there are some proposed modifications to the requirement for actual knowledge, for example, in our take-free rule in section 46 in the accepted proposals. Hence, in New Zealand, as has been observed, registration is not mandatory in the sense of either being an offence not to register, and nor is it required for the security interest to be valid in the debtor's insolvency. The New Zealand Law Reform Commission left the consequences of non-perfection for insolvency proceedings against the debtor to be determined by any specific insolvency law. and I may return to this aspect depending on time. Here, there is certainly reason, as Adam has demonstrated, to ask whether some of the long-standing factors identified in support of vesting can carry weight today in the context of modern commercial markets and practices. A straightforward example, the notion cited in the Whitaker report that as one of the pros and cons, and this was a reason, a pro, which had been indicated that an unsecured creditor may be misled by the absence of a registration on the register into believing that it could advance funds and not rank behind secured creditors when the time comes to recover payment. Seems overly simplistic as a general proposition, at least in current times. As has been pointed out, the debtor can simply grant a security interest any time after the search, which may defeat the unsecured creditor. But given we're somewhere down the track as regards what might be described Section 267 vesting, perhaps one way of framing the question now is perhaps by asking, is there sufficient case for change? This can be a practical question as well as one of principle in weighing policy-driven factors. And this seems to be the approach of the Whitaker report. As Adam's indicated, the report identified a number of arguments for and against Section 267 vesting, and Adam's well canvassed them in his paper. Relevantly, it noted that a small number of respondents argued for deletion. One respondent, whilst not submitting it should be deleted, argued it should not apply to the hiring industry. Some abstained, expressing neither view in either direction, and it appears a majority supported its retention. The report concluded, whilst it's fair to say there was no obvious consensus across those respondents who supported the contention as to the policy basis for retaining the sections, it's clear the majority view is they should not be deleted and there is no clear case for change. What then that occurred to me is that it's perhaps more difficult to assess in a law reform context, at least what might be called the intangible category, or perhaps the behaviour encouraging category of reasons for vesting provisions, which don't sound readily in identifiable or ascertainable costs, and how these are to be weighed and balanced against the potentially or probably actually punitive consequence for an unperfected secured party of losing their interest on insolvency or an insolvency event. I guess these factors include factors such as the maintenance of status quo to which commercial parties can be regarded as generally familiar, and the vesting under the PPSA, at least under 267 and 588 FL, has now been in place for over a decade. At least as regards 267, it seems to have persisted without at least numerous or robust objections from disaffected, unperfected secured parties whose interests are vested in the numerous insolvencies between 2012 and the present. Although from the submissions to the Whitaker report, it's certainly not clear the same can be said of Section 588 FL. This seems to have been the main factor persuading the author of the Whitaker report, as well as the fact there were pros and cons, to conclude there was insufficient cause for change. The other factors which Adam's mentioned are the facilitation of insolvency administrations and the risk of reducing the risk of fraud, that being the latter's policy justification on the federal government's response to 588 FL. This is presumably aimed at discouraging what might be called the wrongful backdating of securities rather than the mere granting of security interests on the eve of formal insolvency. One would think that on the eve of formal insolvency, the facts might present themselves within the current insolvency regime as Adam's described, but proving backdating and deterring that situation seems to be what the government had in mind. There is, of course, a significant empirical problem in ascertaining to what extent that is a real issue. And one presumably would need to canvass the insolvency practitioners perhaps to get some indication of how often that might be a problem, given through the Corporations Act in Section 266 and in current times we've had a prohibition which has probably eliminated that. Against this context in 580 FL, it's also worth noting there are other quite significant costs associated with the innocent failure to comply. applications to extend the time for registration under 588L are frequently sought by parties who fail to register through inadvertence, accident, or the like. If the main purpose of the extension provision is to protect the innocent, the non-fraudsters, or at least those who recognise their error in time and prior to insolvency, it does this at a significant cost in terms of money and time for those parties. They are the most frequent applications brought before the superior courts in respect to the PPSA. And if Section 588FL was dispensed with, so would all the applications required to ameliorate its operation. And this should weigh in the balance as well. I'm sort of conscious of time, so I should note that there are adjacent problems in large insolvencies to deal with how to most efficiently administer the situation of large numbers of PPS registrations. It does advance the liquidator's role to some extent, and liquidators would have to give evidence to what extent to not to have to review unperfected registrations. And there is some reduction in admin to this extent, although the greater problem seems to be caused by large administrations such as Hasty Group and what seems to be the anecdotal evidence of many defunct registrations where secured creditors won't come forward to clarify the position, and the administrator or an external administrator needs to try and deal with that. The government seems to have rejected the Whittaker Report's invitation to examine a solution advanced by ARETA of allowing the liquidator to give a notice, and if the notice is not responded to, permit an effect such as vesting, hence I'm in slightly adjacent territory, and has suggested that reforms to the registration process will assist liquidators. It's not clear to me exactly what they are, but presumably those are the other ones already accepted in the report. This may be something which gets ventilated again if we have a holistic insolvency inquiry. But I think in conclusion, Adam's outlined some good reasons to consider there's merit in reviewing what exactly is the policy behind vesting in the search perhaps for a modern, coherent or compelling reason for or against. But this may involve weighing and balancing the considerations. I think it's fair to say that the way the Whittaker Report developed and the submissions that came before the report did not lead it to be a forum to examine this in great detail. But there is also a need to consider, I guess, at a practical and commercial level, whether there is actually a threshold question of a compelling reason to review the question itself now, amongst other reforms, when we're already well progressed on Australia's PPS journey with much other reform ahead. But well done, Adam, terrific effort.
Thanks, Tony, and of course, thanks, Adam. So we do have several questions online, so I might just go through a couple of those. Sorry, Adam.
Jason, can I interrupt you quickly? I was actually just hoping I just wanted to quickly respond to Tony's point on top of thanking you for your very generous comments and your very insightful comments. I do think this last thing that's raised is this really interesting idea, you know, like we're far down the track. Is there a sufficient case for change, or should we just maintain the status quo? I think someone said something to the effect of, you know, if it ain't broke, don't fix it in the comments. And I do acknowledge that's possibly a reason for taking this off the table. Having said that, I suppose the things I would just kind of want to emphasize in response is I'm particularly concerned about the effect of the vesting provisions on small businesses. And the reason for that is I think it's really hard to reach a representative group of those parties in consultation processes. And that's a general problem, but it's probably especially the case in the context of something as complicated as the Personal Property Securities Act. So it's really hard to say to what extent this does affect them, but I do think that is quite a strong reason to consider that there may be many parties who are being affected by these vesting provisions and thus who are suffering detriment, who it's going to be really hard to get a representative kind of sample of. And the thing I would tie into that is just that that's certainly a theme that, as of course you would both know very well, that we saw came up in the recent JPC report concerning insolvency, which was again canvassing the issues with both 588FL and 267, and shows that even after 10 years of operation of the PPSA, these provisions are still causing harm to some secured parties due to lack of awareness. And that report then kind of investigated, well, what are things that we could do to affect that? And again, it kind of ties back into my point in the paper, which is I actually think perhaps the most effective thing would be to delete the provisions altogether. But I did just kind of want to raise that as something to consider alongside this notion of is there a case for change in the first place? Although I very much appreciate the comment as well as your many other insightful ones.
Okay, so I might just read through some of the questions that have been coming through the Q&A button. So thanks for everyone for submitting your questions. So the first question I'll raise comes from our webinar presenter from the very last webinar, Lindsay Powers. And Lindsay asks, this is a question for Adam, is Section 588FL being subverted in any event by the courts granting extension applications even after an insolvency occurs?
Thank you, Lindsay. That's a very interesting question. And certainly Tony and Jason may have thoughts on this as well. And I know Jason has written about the application of that post-insolvency. I don't think it's necessarily being subverted to the extent that if those applications are being granted so that an insolvency practitioner can extend further secured credit and thus try and save the insolvent company or increase distributions to unsecured creditors. But I don't think that's contrary to what 588FL is trying to do. But it does also just tie into the broader question I have, which is what is 588FL trying to do? So I suppose if you agree with me, and which is that I don't think there is any especially convincing policy reason for 588FL besides perhaps the protection against fraud, which I don't think justifies retaining it, then you'd probably say, well, we're not really concerned with that being undermined if we can't point to exactly what that convincing purpose is in the first place. That's my view anyhow.
We've also got a comment from James Neat, who's over in Adelaide. And he's this is really for you, Adam. You were mentioning about small business people and it being difficult to reach a representative group of them in terms of consultation. James just notes that a good industry group that we could refer to would be the Australian Institute of Credit Managers, who represent a number of those parties. So thanks, James. And then we have a comment from Anonymous, just noting that fraud was a ubiquitous issue before with retention of title clauses, before registration of them was required, to the point that documents with GST clauses were being backdated back into the mid-1990s. And so they found this amusing, if not somewhat remunerative. So that's just a comment rather than a question. Then we have a question from John Ward. Would deletion of Section 267 588FL give rise to a different, arguably fairer result, or would the priority in taking free rules under the PPSA apply in the case of an owner of equipment under PPS lease to the insolvent and externally administered grant or company in a contest with a perfected secured creditor, for example, the Forge case, where the lessor lost $100 million worth of equipment?
I'll happily jump in there. I think it would give rise to an arguably fairer result. But by fairer, I mean, it's a difficult word to use in this context. What I really mean is I'm happy to redistribute value away from a lessor in that position if there's some convincing need to do so. But because I don't think there is a convincing need to do so, I think the better conclusion would be, well, if there aren't other competing secured parties, purchasers, lessors, people with other property interests in that same collateral, I think the preferable result would be to allow the lessor to prevail, at least to the extent that economically that means they're prevailing over unsecured creditors. I would also flag, if we do carve out PPS leases which don't otherwise secure payment or performance of an obligation from Section 267, which was the recommendation of the Whittaker report and has been accepted in that government response, that would also solve this problem. Although, just as I indicated in the paper, it would give rise to the separate problem of needing to distinguish between leases that do or do not secure payment or performance of an obligation. So those are two different ways of getting to that outcome, which I think is probably a better outcome. But my preferable route of achieving that which I argue in the paper also has further benefits, is to just delete 267 and 588 FL.
Then we have a comment from Mark McKillop. In my view, the policy purposes served are to give an incentive to secured parties to register so that their priorities are transparently regulated and so that their interests can be regulated via a liquidator in insolvency. That was a primary purpose of universal substance over form regulation of securities. Why would you register if your interest will not vest?
That's I love that question because I wish I would have addressed this more clearly when I went through the paper. My argument in the paper is, if you're a secured party, there is already there is a big stick, which is a very strong incentive for you to perfect your security interest, including by way of registration, which is you are still at risk of losing out to other competing parties with property interests, even if your security interest is not at risk of vesting in the grantor. And that is a very strong incentive, because if another one of those parties is a purchaser, or another one of those parties is another secured party whose claim exhausts the value of the collateral altogether, you may be essentially just as worse off as you are if your security interest does vest in the grantor. So that's the argument that I make in the paper. I think there's already a sufficiently strong incentive for registration or otherwise perfecting your security interest.
So I've just noticed the time. We've just ticked over 7 o'clock. So I'm sorry for those whose questions we weren't able to get to. But thanks everyone for giving up your time tonight. I suspect some of those questions will be answered in Adam's paper, which, as I said at the start, we will be distributing. Thanks very much, Adam, for agreeing to distribute that paper. We'll be distributing to everyone who has registered for this webinar. This webinar, as I said, is being recorded, and so we'll post up the recording to the Sydney Law School YouTube page, and we'll send a link out to everyone who's registered for this session. So thanks everyone for giving up your time tonight, and thanks in particular to Tony and Adam for presenting a very engaging and thought-provoking webinar. Thanks everyone.
Thanks, Jason. Thanks, Tony.